All right. It's about what's 4 p.m. Eastern, 1 p.m. Pacific. I think we can get this going. First, I want to thank everyone for attending this fireside chat on deep dive into how operators and advisors can get ahead of risk, regulation, and coverage gaps in the evolving cannabis landscape. So yeah, again, thank you everyone for attending. My name is Jared Schwass. I'm a partner at Cogent, and I have a fellow partner, Sohiko Ono, and we are joined by Karma Cannabis Insurance, Brian Moser, and Jacob Landman. Um, I'll introduce myself first, and I'll pass it to Suhiko, and then we'll do some quick introductions. I'm a practicing attorney for about 10 years now. Been working in the cannabis space and advising cannabis clients since 2017. Started with licensing and on the sales side of M&A and regulatory matters, and then transitioned into the buy side M&A, working with large MSOs and billion-dollar transactions. And most recently, I represented a local county here in California on advising and administering their cannabis program. And then I recently jumped back out into the private sector to advise cannabis clients. So we'll pass it to Sohiko to introduce himself.
Yeah, thank you, Jared. Yes, also partner at Cogent with Jared. My experience in the cannabis space actually was much more heavily on the operational side. Started an operation, a cultivation facility in Massachusetts, starting in we'll call it 2019, signed the lease, commence operations 2020, and then some operational experience for a large, diversified, vertically integrated operator in New York, as well as obviously, doing the full spectrum, sort of generalist on the legal side, licensed in New York.
Perfect, thank you. And then from Karma, we have Jacob Landman and Brian Moser. Jacob, you want to start introduce yourself, and then Brian follow him?
Sure. It's a pleasure to be here. I appreciate everyone's time in joining us. My name is Jacob Landman. First and foremost, I'm a medical cannabis patient. I credit it with saving my life. And then I was an early employee at Ethos Cannabis and, got my bearings down as an operator of a multi-state entity. And then I realized that there was an opportunity to better serve the cannabis market from the insurance perspective. So I founded Karma Cannabis Insurance about 5 years ago, and we launched in Q4 of last year.
Hi, everyone. My name is Brian Mosser, Executive Vice President at Karma. Excited to be on this call. It's an important call because there's a lot of overlap between the legal assistance that's out there and also risk management. So and I think we play a good part in that, and we can definitely help and advise. And that's the biggest thing I think the takeaway will be from today. Will be how asking questions is a good thing, especially in the cannabis industry as it's changing every single day. So excited for this panel.
You're right. Asking questions is definitely key. And how we're going to run this panel, it's more going to be a fireside chat. I'll pose a question, and all the panelists will have a take, and we'll just have a ongoing conversation. Then it's going to provide utility and great information for you about how you can help or run or organize your operation to stay ahead of the evolving landscape and regulations. So let's kind of dive into it first. Given there is a lot of news out there and a lot of headlines about federal regulations and new state regulations coming up on a regular basis. So, how can attorneys and insurance brokers create risk management strategies for cannabis operators to stay ahead of those shifts or adapt to those regulation shifts as they occur? So Hiko, we'll kind of pass it to you, and then we'll kind of just go around if you guys like.
Sure. Yeah, that sounds great. Thank you, Jared. So, I think the key here is really kind of the difficulty of dealing with the landscape as it exists today, while trying to anticipate the changes, right? And obviously the descheduling or rescheduling conversation, which just keeps emerging, which is itself its own can of worms. But I think part of the response to that is sort of, again, understanding, under what sort of framework where we would be required to operate. So, at the federal level, understanding our operational requirements, let's say at the cultivation level, if for example, it's descheduled or even rescheduled in some cases, but being held to GAP standards, good agricultural practices, right, under USDA. And then, of course, at the manufacturing level, the GMP requirements. Some states, like for example, New York, in the regulations calls out GMP, and so it's really a good practice to start, operating like that. But then it really kind of leads into every operational piece of this. Especially if you're a multi-state operator and you have contracts, which potentially start to theoretically could then cover operations across states as opposed to being territory specific, right? So renegotiation, restructuring of contracts and agreements in that regard. Of course, also opening up federal courts, the potential of that. Obviously, the 280E conversation, which is huge, a giant topic in and of itself. So I'll just kind of rattle off some additional thoughts. Obviously, trademark protection, IP. That's a big one, right? And so, kind of understanding how that may play out and trying to get ahead of that. And then, of course, really kind of understanding what that transition is going to look like. Again, almost very sort of unpredictable, right? What happens during the transition period? Let's say, for example, it's rescheduled. To what extent are products already in market going to be held to the standards during that transaction, right? Do we have to sort of reach out and recall, or what kind of consequences happen there? I think there's this covers so many topics, so I'm going to kind of leave it at that shotgun response. There's more to say about that, but just kind of getting the ball rolling on that topic.
Yeah, appreciate it. And then one thing, I just to add on to that, with the changing, and then as you mentioned, these federal agencies will then have a regulatory standpoint and uh, incentive to dive in and regulate these industries. Is that so that you're going to have to adapt to these new regulations on the federal side? And one way to kind of get ahead of that from operational side is to make sure that your compliance operations are tightened up, all and your SOPs are first off locatable, second off that they're fully implemented, and so that because that way when change does happen, you can go directly to the SOPs. You can implement the change, train the change as quick as possible, and make it as quick as possible. Streamline the process whenever a change is needed. I feel like there's a lot of operators out there that maybe not adhere strictly to SOPs. You have to submit them with the application, but they may not strictly adhere to them. If you going back and tighten up and your compliance operations now would allow you to implement quick changes in the future, given that there's going to be new additional agencies on the oversight realm. Jacob and Brian, what would you see about reshaping insurance strategies if and when federal descheduling or rescheduling occurs?
Go ahead, Brian.
Go ahead, Jake. You want to go ahead and take it?
Well, I'll just pose as this. As a previous operator, it's an industry that will callous you quickly. We all know with 280E how difficult it is. No interstate commerce. It's very, very difficult, and I would like to think it'll get easier over time. But I know as an operator, you're spread thin. It's a lean teams. You're already getting an uphill battle from the unit economics of each state you're in. So I really pose it as this is a dynamic industry that is constantly changing, and it's really about the team you have around you and working proactively. From a risk management standpoint, I think the contracts you have with vendors, M&A, It's all just a big puzzle, and having specialists on your team, whether it's risk management or on the law side, really reduces the exposure down line because you have no idea. It could be descheduled, it could be rescheduled, but having the proper team around you allows you to quickly refocus and change if you need to. But it's dynamic, it's changing, and I really think it's a proactive approach that allows you to get over these hurdles quickly.
Yeah, I agree. That there's a lot of, I mean, I think that everyone's pushing for this, the federal, whether it's deregulation or regulatory or decriminalizing the from a federal level, but it doesn't eliminate it. It reduces some of the heartburn and the headache that we all deal with, but it's certainly not going to eliminate it. And in doing that, it's going to create um, more restrictions, from a federal standpoint that we all need to be mindful of. Interstate shipments, the track and trace, those type of things. The DOT, how is that gonna? There's so many facets to this that it's all part of that risk management. And really, like Jake was saying, really staying on top of it and understanding these are changing. Everything in each state, I mean, every month we get the notices on all the different regulatory changes. So really to work closely with your risk management team is crucial.
And let me add
Yeah,
one more
yeah.
point. I think there's something to be spoken about specialists in today's society, but especially in cannabis and hemp. And you wouldn't have a grower run your retail operations. It's a different background. And I think bringing the right people on your team with a specialist background, like you guys at Cogent Law or us on the Karma Cannabis side, really allows you to hedge your bet in this, rapidly evolving segment.
I couldn't agree more. One topic I did kind of jump into, I wanted to give Suhiko a chance to jump as well, is the practical steps to foolproof your compliance. And I agree, having a great team around you can help you quickly adapt, and having those specialists that stay informed for you, because there's so much going on, you can't really stay on top. So if you have your specialists that are they are always going to be up to date and well informed on all the upcoming changes. It makes life a lot easier, in addition to having those SOPs and processes in place.
Yeah.
And from rather than going from a future uh, look, that's kind of look back at the current stance. From from a legal standpoint, what's some of the biggest blind spots that you're seeing that some people don't fully understand, and from an insurance standpoint don't price in accordingly? I'll take one blind spot that I really do see in California, especially, is the record retention requirements and adherence to the requirements. And as I mentioned, adherence to the SOPs and training on those SOPs, and reconciliation, ensure that the employees, even if they are trained, that they're adhering to all the SOPs. I believe those are blind spots that I've been seeing in California. Suhiko, have you encountered what is your biggest blind spot that you're seeing on your side?
Yeah, I think that's true. From that sort of operational side and really kind of understanding the underlying principles, right, of the record retention, as you pointed that out, the SOPs themselves, down through, and I think this is a big one, sort of the HR and employment pieces, right? Making sure that everything is really buttoned up, all the T's, all the I's are dotted and the T's are crossed. I think too, as it a difficult but very important topic is the labor piece of this, and the liability associated. As you grow and as you scale, you hire more employees. What I've seen is that it's really not a question of whether, but when you're going to have to deal with various labor issues. And so the more that you can have all of the documentation buttoned up on the front end, to Jared's point, making sure that the SOPs are not just there, but that they're trained upon, and that people are aware of them and they follow the protocols, they follow the procedures. And then on the back end, that you actually have and I'll let I'll let Jacob and Brian talk more to this, but protecting yourself from potential liability from the insurance side. I think it's just absolutely critical, and it has to be priced in, and you have to assume if you're scaling, you're going to deal with those issues.
But that's a key word, is assume, and that's from a risk management standpoint. Talking to a lot of the cannabis brokers that we talk to, and then hearing from their customers, their insureds is, their insured assumed that they had coverage, and that's the worst from a risk management standpoint. That's the worst thing you could ever do is just think, I'll be okay. I have a current policy, and we found also a lot of the cannabis operators, they're entrepreneurs, so they own other businesses, they own other commercial businesses, and they're used to working in the standard insurance market. Oh, I have Travelers or Chubb, and they won't cover the cannabis, and back to that, they're assuming that they have coverage on their building, and that's why it's so important to talk to a specialist that understands cannabis and is working with the correct markets that are identifying what you're doing, and the coverage is in place for you correctly.
Yeah, and just to riff off of that, so a couple of things on what everyone brought up. So one, on the SOPs, I really believe, and we believe, that your compliance data is your insurance, in a sense, that you should be documenting it, you should be living by those SOPs and really follow them to mitigate. But then two, on Brian's side, and having a specialist actually understand your operation. I mean, D&O and professional lines wasn't truly offered that much 5 years ago. That's a huge hole. Cyber is a huge risk right now, and we're seeing an uptick. I mean, the amount of phishing emails we're seeing from our clients is off the charts right now. And having specialists along with the SOPs that can guide you, we really think plugs all the potential holes and creates a true transfer of risk backed by a team that you can feel strongly, has, your I's dotted and your T's crossed.
Yeah.
Oh, go ahead, Sohiga.
Well, I was just, yeah, no, I mean, again, these topics are huge, and we could, go on each one on their own, but, to the extent too, one of the things I think, talking about DO and the professional protections, one of the challenges we face in cannabis is you have to be very creative in your financing, because traditional financing avenues just really aren't there. And what that results in are extremely complicated cap stacks and structuring. And so with that, of course, comes potential liability, right? Misunderstandings and litigation over who owns and who controls what. And so that, again, that's something that you have to be careful on the structuring and the planning side of it, but it's almost impossible to avoid some of that potential, just the complexity, again, because you have to be very creative to raise capital in this industry.
Yeah, and
Couldn't
it's
agree
a
more.
very, very good point. And I feel like that is a big risk exposure that's overlooked, is the capital structure, the corporate structure, and fully understanding not only who's involved, but who has the ability to direct the organization and make calls. And I've seen plenty of disputes arising out of disgruntled partners that thought they had this much authority, but they didn't. And so that's a huge reason why you should get your team, your legal team involved early. And in addition to getting them involved early, how do you guys see that the legal counsel and insurance brokers can work together to proactively structure coverage and risk mitigation plans?
Well, that's very important as you're talking about scale, and as you're talking about where we are not only today, but where what is your your 24-month plan? What is your 5-year plan? So that way you're with the correct carrier that can grow with you. So you're not at the 11th hour trying to find additional coverage. What we're seeing a lot of, especially this year, is as the economy itself is loosened up, or as continues to not grow, the property owners, the property management companies, are allowing cannabis operators to be within their their footprint or their portfolio, and the cannabis operators are then scrambling to find the right coverage to match those requirements. So that's very important to have as you're talking about, yes, we can place coverage for you today, but what is your plan long term? Are you going to be going, are you going to be going to multiple states? Are you going to be creating a new grow operation or testing operation so we can place you with the right carrier, or at least have that in the forefront as we're talking about your renewal in the future?
Yeah, I think I would add too, and I've seen now, I think we all have countless pro formas, right? Either projected, contemplated transactions or startup companies. And the incentive, especially if you're raising capital, is you want that P&L to look really, really attractive, right? You want to see profit margins and all of that. And so what you tend to see as a line item that is either completely missed, overlooked, or underpriced is that front end, right? Making sure that you are protecting yourself because, again, operationally, you're either going to pay for it and mitigate that downside risk on the front end, right? Or you will pay for it on the back end. And even simple things like, avoiding litigation through settlement agreements, I promise you will cost you more money than protecting it on the front end.
Yeah, and to kind of dive into that a little bit more, as Brian mentioned about if you're looking to grow and you're looking at your 5 to 10 year plan, it's important to ensure that if you're a legal counsel or if you're hiring an attorney that have that attorney come in and not just start changing things just because they that's the way they want, but that individual gets a full understanding of your operation, comes in and looks at all your SOPs, does inspections, looks at all your corporate records, your back end capital structure and all those agreements. And that way your attorney will be able to spot the issues, because if you're looking to grow into multiple states, if you're looking to add licenses, if you're not even just licensed, if you're looking to add additional products or partnerships to grow those products, you need to make sure that everything in the back end is already solidified. So if we make a move, you don't have someone coming in, as CK was mentioned, settlements are much cheaper than litigation. If you're trying to make a move and you have this unknown legal issue that can pop up all of a sudden because you're growing, people can think, you have money, I'm gonna now's my time, now's my opportunity to kind of stunt that growth. And if you can catch that early and be proactive about it and approach that and fix it as soon as before it becomes an issue, you can have that 5 year plan can be executed, or else you're with limited speed bumps. There's always going to be speed bumps, but with limited speed bumps.
Absolutely.
Yeah,
So
well,
with your risk transfer and when you're building out your contracts, your vendor contracts, talking about your held harmless or hold harmless agreements, your indemnification agreements, what does that language look like to your vendors? And that's really going to come into play if there's product recall. Who's the one that's really going to be impacted on product recall? Mislabeling. If there's a mislabeling issue with one of your vendors, you want to have that. You want to be proactive upfront and kind of go through a lot of your what if scenarios up front. You certainly don't want to be reacting to that and assuming that you had coverage or assuming that their contract was going to give you going to help if there was a recall or if there was a mislabel. We had one a few months ago where there was the packages were mislabeled and they had to recall all that information or all those packages and products. So those are the scenarios you want to run through with counsel and with your risk management team and make sure you have the right coverage in place.
I think, Brian, if I may add to that too, I think, a very, very common in the past couple of years structuring that we've seen is based on this so-called asset light brand licensing model. And in particular, issues like that, right? And you have to be very careful, right? Because ultimately, the teeth for any of the regulations, ultimately for these state agencies, is ultimately it's tied to the license holder, right?
Right.
That's where they have the authority. That's where the teeth are. So you have to be very careful on those contracts when it comes to non-compliant issues like labeling, like potentially who's responsible for product recalls. And then, of course, the marketing and advertising laws, which are very, very strict. And there's various state attempts to try to, gain teeth, right? So in New York, for example, the Type 3 processor license for brands, theoretically they can yank a brand, but it doesn't really absolve the processor license from liability there. So again, yeah, just emphasizing that point, it's critical.
And to go off of that, I think it just illustrates how complex each economy is in cannabis. Each state has different laws, they're changing by the month. And while we all agree the proactive nature is incredibly important, I also think having specialists that have walked a mile in your shoe, whether it's the folks at Cogent Law or us, allow you to get around these issues in a much more meaningful and fast way. But yeah, I agree with all those, and it's ultra important in our opinion to be proactive on this.
Yeah, and one way to be proactive is to have early communication. And by having by I- by having that early communication, whether it's you maybe you're entering a simple partnership deal or a simple transaction with a lifelong friend or a partner that you've been working with forever, but haven't just finally now you taken on a different role. It's crucial that you bring in counsel and your risk management team early. I can't express that enough. Is that it's much more efficient from both an operator standpoint and from a legal standpoint to have those conversations early and be fully transparent. You must be fully transparent. As an attorney, you can't be properly represented if you're hiding the ball from your own attorney. Your attorney's there to help. Attorney-client privilege protects any communications. If you're worried about maybe you're not doing something full board, or maybe you just don't want some information slipping out, all communications with your attorney is protected by attorney-client privilege. So I really can't stress enough the early involvement to keep any sort of issue small or prevent any issues from happening. Whether it's a simple clause in a deal, as Brian was mentioning about recalls, finding those indemnification and recall obligations within those, or there's so many different avenues that could pop up, or issues that could pop up that you may not know or perceive as potential issues, whether because you have a existing relationship with that individual or whatnot. I feel like that kind of happens a lot as you go into a deal with a friend or someone that you have a prior relationship with, and you think everything's good. Everything's great at the honeymoon stage, but and no one ever goes into a marriage thinking that it's going to get in divorce. But once divorce happens, it gets messy and the teeth come out. And so that's
absolutely, yep. And we see that from an EPLI standpoint, from a professional standpoint. We've seen those claims come in where they hired their next door neighbor, they hired their high school friend, best friend, from college, and it went sideways, and all of a sudden they were hit with a wrongful termination lawsuit, and they thought, oh, they would never go wrong. So that's where, leading up to understanding what is your hiring process, and a lot of times when you ask, we don't have one. We don't have. So that's where working with counsel, working with your risk manager, putting together those processes on hiring, firing, discipline. When you have to discipline an employee, how do you do that? And a lot of them, they don't have a process, and you need to have that standard. You need to have that SOP on hiring, the employee handbook. That whole process is very important. So I agree 100% there.
and
Yeah,
then
the running joke. Oh, I'm sorry. Go ahead, Jared. Yeah.
no, all you.
Okay. Yeah. Running joke being that there's only two times when, problems arise, and it's when you're losing money or when you're making money.
Very true.
And to get into a little bit of maybe misunderstood or underutilized insurance. What from Jacob and Brian, your standpoint, what are some type of coverages that you've seen and are underutilized in the industry?
Go ahead, Brian.
No, go ahead, Jake. You can tell you I've been talking too long.
So, obviously the professional lines, D&O, E&O, EPLI, cyber, but I think what Brian really got at, which we can go down a Pandora's box, but the product liability. Obviously, vape pens are one of the biggest growing SKUs, especially with COVID and, the changing consumption habits. Hemp drinks are, an absolute unbelievable segment right now. So I think it's really understanding the product recall, the withdrawal, and the true what is in your policy. But if I had to do one thing, it would be the professional lines. I think investors are not aware that they are in for these claims and think you're just putting money in, and they really should have the protection just like any other business of similar size.
No, I agree. And the other thing that is very important in our industry is the product liability, product recall, product injury, and that's a big part of that. And a lot of it comes with, I thought I had that coverage. I thought I bought a GL policy. I thought that was included. And most times you have to buy that separately or it's excluded, and then you have to buy it back. So understanding what that health hazard is, and what you're selling is a huge part of that. The other one is the crop coverage, and understanding what from a grow standpoint of growers, what is that plant worth? What is that seedling worth all the way through to when it's harvested? There's a value all the way through that stage, and understanding that if there's a loss, what is the insured out, and explaining it to the insured that way helps them understand the exposure that they have, and those numbers add up really quickly. If you said, hey, if you lost half your grow operation, what would that cost? What would that cause as far as a revenue loss for you? And those numbers, they add up very quickly when you do it that way, and making sure that they have the correct coverage in place.
And one
It's
more point on
kind
that. Oh, I'm sorry, Jared.
of no.
I
Okay.
think, Brian, that was a terrific point. But, I think there unfortunately needs to be a reframing of legal and insurance professionals in cannabis. It's not something that's working against you. We're here to amplify and help your business and help you reach the next level. And having these early conversations, having someone that understands, the journey of your crop and how much it means to your business allows you, to reduce those downline issues. Sorry, Jared, go ahead.
No, no, you're all good. And I just kind of want to dive deeper into the crop insurance, and I believe that is misunderstood. I represent a lot of farmers up in Northern California, and kind of I believe there's a misunderstanding of what crop insurance is for, what it covers, and what exclusions are for that. So could you, if you guys don't mind, kind of go into the importance of crop insurance and like what would it cover?
Go ahead, Jake.
So the crop coverage is truly the coverage for the plant material before it is harvested and then it is stock, essentially. But as you know, when you start an operation, those first harvests are extremely important, especially with debt on the horizon. So having the coverage rather than going bare is really important, but also to being able to understand where it is in terms of money value at the harvest stage. Obviously, when you harvest it, it's arguably the most profitable and the most cash heavy, whereas when it's an early seedling it's not. But really, it's these growers are massive and a massive part of these operations bottom line. So why not transfer the risk in a way that any other ag segment does, and why not have a product that's truly built for the different harvest stages rather than a tulip farm repackaged into this. But yeah, I think it's extremely crucial, especially as we see interstate commerce and especially as we see larger grows, which is akin to other ags industries.
Yeah, and that kind of goes into the next topic I want to talk to is about how might federal rescheduling and state or impact underwriting, pricing, and access to new insurance types.
You got it, Brian.
Well, yeah, I mean it's scary. I mean, as far as from the way we're looking at it, and to see what once the Fed gets a hold of it, if when they eventually do, you have the EPA, or the EPA that's going to look into it. You have your one of the questions we're starting to see more is just environmental, and I think that's going to be a big part of the grow operations, and the disposal of the product, of the waste product. And right now, there's really not a whole lot of coverage for that. So there's going to be additional regulation, as the federal government gets involved, that they're going to continue to regulate it, which is going to open up more insurance related issues. That's going to come downstream from that. And the biggest thing big part of that is going to be the Safe Banking Act and how that's going to, as far as the ID and the track and trace. Right now, each state is doing their own track and trace. Is that going to be is that going to turn into a federal track and trace? So there's little things like that, like Jake talked about, going across state lines, and how that's going to be impacted, which is going to be DOT, which is then going to be a commercial auto policy. So there's a lot of different things that are going to trigger that. It's certainly not going to make the world easier. It's gonna start more questions. There's gonna be more regulation with it.
Yeah,
But
and
I
then
think
to
it's going to deliver even more products that'll be able to transfer that risk in a more meaningful way. And I think, although it is scary, it'll be a greater net benefit to the industry as we
Sure.
usher in. Abolishing 280E allows these operators to reduce their pressures that normal businesses don't have and spend more time on risk management, on legal counsel, which hopefully will reduce these issues down the line.
yeah, and I 100% agree. And also, from a legal and business perspective, the rescheduling and safe banking passage would allow is that it does remove that 280E restrictions for business deductions. So you'd want to make sure that your tax advice and tax counsel are tuned to that and can move and shift accordingly. And I feel like there's also going to be little bit pent up capital that's going to flow into the market, because they're going to open up traditional markets more. It's not going to be as much as it would have been if it happened 3 to 5 years ago, but I believe there still is a little pent up capital that's going to flow, which increases the need to make sure that your legal foundation, your agreements, your compliance, your SOPs, your HR, all those foundational pieces to your business are stable, are rock solid, so that you can take advantage of these new markets that would open up to you from rescheduling or safe banking. You can take advantage of new traditional capital markets. You can enter new markets easily with by having a solid foundation. You can then partner with a company over across state lines really quickly. And so I think having it's been a theme of this discussion, I believe, is having that legal and insurance foundation is essential to be able to take advantage of any sort of growth potential with federal rescheduling or descheduling.
Yeah, I think I would add to that. This brought to mind an issue that I was dealing with very recently, and with descheduling and or safe banking, or at least some sort of opening up in that regard, so much structuring right now is really an attempt to dance around the regulatory framework and the limitations on banking, right? And so planning, tax planning and structuring, allocations of cost and cost accounting, that can all be done in a much more, let's say, business oriented framework, as opposed to, again, dancing around a structure that is artificially imposed. And so, taking advantage of affiliated group and consolidated returns, but structuring such that it all actually plays out. But again, just beating the drum of the theme of this is really getting involved in the advice of operators and specialists that can really help to kind of game this out and think about what it looks like in a world where these constraints are no longer there.
So the key word for this part of the discussion for me was advantage. And I think it's a great point. We've been talking about proactive, but the time in which you can take advantage of these situations is extremely small in cannabis. We know how fast this industry moves, especially once it's federally legalized, whatever way it happens, descheduled, rescheduled, that door's open and we're never going to go back to where we are today. So I think having the right team, building your operation properly from SOPs, compliance, HR, risk management allows you to take advantage more meaningfully, but faster, where others might not be able, and that should be an advantage to your business.
And speaking about moving faster, and I, would be remiss of not bringing up this topic just because the prevalence we see it in everyday life is, the growth of AI, data analytics, technology tools. Do you guys see those playing a bigger role in identifying emerging risks or just emerging potentials for cannabis operators?
Absolutely. We
Yeah.
really pride ourselves on the use of AI, LLMs. We have one of the largest proprietary data lakes, as we call it, and we're constantly running analytics on different risks, different way to look at risk, different trends happening. And as the data accrues, I mean, it's not 10 years ago when there was no claims, there's a lack of data. We think there'll be more trends that'll, pop up to us in which we can deliver a more complementary product and a better experience for the customer. But we lean heavily into it and think it's a huge asset to deliver a better customer service and product to the insurance world and the carriers and the reinsurers, but more importantly to the operators.
Yeah, I would throw in, I've been fascinated by the LLMs, from the moment I found them. But it's an extremely double-edged sword, right? So if you don't understand the framework, right, if you don't really understand the navigation of the law, then the use of a generative AI and LLM to try to sort of cut out a legal professional, while it's possible, is very dangerous and wrought with all kinds of potential risks. That said, on the other side of that spectrum, the generative AI revolution, and in particular, in my mind, sort of the LexisNexis and Westlaw have just launched. It's not even 2 years old. And in New York, there's a continuing legal education requirement. And I've done my best to sort of attend every single one around the AI and the concerns around things like um, uh, uh, hallucinations, right? So there's all kinds of issues where attorneys themselves will actually submit court documents with cases that don't exist. Now, less and less that's an issue, but what it does allow us to do is to be nimble. And so, to the theme of this conversation, right? There are all kinds of business models that are emerging out of this. I think Cogent is one that is a good case in point, where now, what used to take a white shoe law firm, an army of first, second, and third year associate attorneys, a week to research can now be done, while doing a webinar, on risk management. Now that's only slightly an exaggeration, but put in the hands of an experienced attorney, you can leverage that. And now the cost efficiency to provide these services we're talking about has now just skyrocketed. So again, I'd be careful, right? You don't want to just go it yourself if you don't really have any experience in the law, but it does allow some, innovative entrepreneurial attorneys to really leverage what's happening and be very cost effective and efficient on all these issues.
Yeah, and just to second that, I do believe that AI and the generative models now are, they augment the human ability to, as you mentioned, a smaller law firm can now take on larger tasks, and you don't need an army of associate attorneys to take on certain tasks. But I do think, kind of reiterate your concern. I do think that we're going to see a lot of it could cause a lot more issues if you don't know what to catch, because the AI, for my use of it, sometimes the AI it's lazy, and sometimes it's lazy and it just wants to produce what it thinks you want to hear. And so if you're not able to catch what's wrong with it, you think, oh, that looks great, let's just put that forward, and you wouldn't know that's an issue until it becomes an issue. For example, I did some coding through AI, and it produced kind of what I wanted, but not really. But I can't go in and fix it because I don't know coding, And so that's similar to, if you're looking to generate a contract, it looks kind of right, you like what you want, but to a seasoned expert, that's not what you want, and you don't really, you're not going to know what you don't know. And so I do think, but and from operating standpoint, I think just the data analytics with products, especially with cultivation and manufacturing, just getting the data of their own products and the creation process within those products is gonna, it just like any other industry. I think it's gonna help and help the grow and help make everyone's product better at the end of the day. Um,
Jared, may I build off of that? I think
yes.
that's a great point in taking it to the operator landscape. I don't think we really know how AI and LM models are really going to impact the industry. Maybe on, the terpene, the flavors, analysis of, your grows, your cultivation. But I think there's use cases that we really don't even have an idea of yet that could come about in 10 years. And clearly on the law side, on the risk management side, you should use it to augment your work and amplify. I thought that was a great way of putting it, but obviously be careful. And I think having law firms, risk managers that truly understand the risks of it, but how to amplify your workload, allow you to hedge that while remaining on the forefront of what's to come.
Yeah, and so I wanted to give last 10 minutes for questions. So we'll head into, before we jump into the Q&A session, I want to kind of give, do you guys have one piece of advice for 2025 going to 2026 that you'd give to operators, service providers to stay ahead of both regulation and risk? And so my one advice, and it's funny because it's kind of been the theme of this as well, is get surround yourself with a proactive team of specialists that that understand and stay updated on the regulations, can understand how to navigate changing regulations and assess risks. I in the this environment where we've been and we're since, in California, it's the regulations been out since 2017. We've probably seen 5 changes, 6 7 changes since then. And so I know operators are seasoned at seeing at these changing risks, but if you get those specialists, you don't have to be so involved and so overcome by it. You can lean on people, so you can open up and really assess your business while you take the compliance part of it, and you allow someone to kind of lean on someone to kind of take that and guide your business on those kind of regulatory changes. So
I agree.
Sahika,
My
go
one
ahead.
piece, I'm sorry, my one piece would be teamwork makes the dream work. And, building off of what you said, Jared, having the proper team. I mean, just look at California, look at Prop 215. It's a totally different market than what it was, back in the day. And being able to put the right team around yourself without egos that truly cares about your business and putting you in the best position, I think sets you up to hedge against this complex future in front of us.
Yeah, I think the biggest thing is don't be afraid to ask questions. If there's one takeaway from this is talk with your counsel, talk with, I know we have a lot of different people on the call that are listening in. So if you're a broker, make sure you're reaching out to your insurance, quarterly conversations, even just a quick, hey, what are you seeing in the market? Talk to the people that are out there and get their feedback, and that allows you as the broker to come back to your carrier partners and say, hey, this is what we're hearing. This is what we're seeing in the next 6 months. So communication is key. Just having those conversations. Don't assume, have those sometimes hard conversations, but that's the biggest thing is schedule those calls and talk to the people that are out on the street and they're hearing what's going on. That's the biggest thing.
Yeah, I think you all covered. I guess I would just add, sort of on the operational side, as you're planning this out and you are putting together your pro formas and you're looking at a P&L, understand and accept the industry has now come to a point of inflection, right? Where sound operations, operating on what is actually very thin margins, right? This is not the days of legacy or even early cannabis. In Massachusetts, when I started, wholesale flower was 4,000 a pound. And those days are no longer. And there's a huge incentive, and it's very it's seductive to want to make the P&L look better by trying to pretend that the risk isn't there. But I can't stress enough, price in that risk in your P&L and make sure it's covered, because you will pay for it one way or another.
Awesome, awesome advice. So it looks like we have a couple Q&A questions. First, to Brian and Jacob, from your vantage point at Karma, what emerging risks do you think cannabis operators are underestimating as we move into 2025, especially in terms of liability or coverage gaps?
Jake, you want to
You got
start?
it.
And I'll jump in.
You could start, Brian. I'll jump in.
I think the biggest coverage gap is as we're getting into, as cannabis is starting to shift into the hemp derived drinks, the THC drinks. That goes back to that word we've used the last hour, is they assume they have coverage, and that's the one thing as you get into distribution of those hemp derived drinks. They need to make sure that they have the correct coverage there. So there's definitely a gap in coverage when it comes to that. And that's one thing that we've seen in the last 6 months, as that's been a new emerging market. We've seen where there's a lot of brokers and insureds thinking that they automatically had coverage on their current policy because they had their retail policy or their dispensary policy gave them coverage for that the hemp derived drink.
Yeah, I couldn't agree more. And, I really think it's having that risk analysis on, your business, your current policies. You guys talked about the price per pound, the external pressures that operators have. I mean, in the CBD market, there's opportunities to bring in hemp-derived CBD into your medical cannabis operation, save money. But having someone that understands what you're doing, your operation, and the policies and the transfer of risk. I mean, especially going to these hemp-derived drinks too. But really, it's just having the analysis of your policy stack and where there might be holes in there.
Perfect. The second question to me and Suhiko, where do you see the biggest disconnect between what legal teams advise versus what insurers actually underwrite? And how can operators bridge that gap?
Good question. I mean, I think one of the ones that really jumps out to me, the first one, and there are several, but the question of crop insurance, and really understanding the exclusions, and in particular, right, in New York, where now, most of again, where I'm licensed and most of my operational experience recently, most are outdoor cultivators, right? And so, the question then becomes, how do you balance the fact that I've only found one underwriter so far that would even come close to touching outdoor crop insurance, and the exclusions made it such that it wasn't worth it. And so in that regard, there was a tension, right? Now the legal team, understand also lawyers are human beings with their own incentive structures, right? And the job of an attorney is to point out the risk, right? And then the job of the operator is to understand that risk and navigate through that, right? And so I think what it really comes down to who you are using as your advisors, right? That's very important. The choice of who you use and the experience that and the perspective that they take is critical. It's absolutely critical. And so there's always going to be those tensions, right? But it's the ability to identify those tensions and then to make a business decision based on the best experience, the best information that you can gather.
Yeah, and kind of second that is the biggest gap I see is the misunderstanding of what's going to be excluded and not. And so I think how to bridge that is to, not only fully review and understand your exclusions, but also following your SOPs, ensuring that your operation is fully compliant, is the best bridge to kind of not even have to worry about what's excluded. So you don't have to dive into, because the reason the SOPs are there is to ensure properly run operations, to limit the risk of needing insurance coverage, of needing any sort of coverage. And so I think that's kind of the best way to bridge it, is to is to tighten up the compliance and tighten up those SOPs to make sure that they're completely adhered to as well. And then hold on one second. And sorry, I'm just trying to figure out this the Q&A section. Oh, there it is. Okay. Okay, we have a question from Renita. I'm in risk management and research here in Texas with OSHA and HR certifications. I'd love advice on which educational path or certifications best help transition into cannabis compliance and risk analytics.
Yeah, it's especially in Texas. That's a great question. In Texas, obviously, having a workplace safety program in place is key. There, as far as cannabis goes, there's nothing specific to cannabis. I would say, as far as I'm aware of, but understanding the SOP, having the training, having the SOP development, and then checking it, having your monthly, your 30, 60, 90-day checks on it. And then also the biggest thing on those HR certifications is just making sure that you're following the current law, the state law for compliance. And then the biggest thing from a risk management standpoint that we love to see, and so do our carriers, is having the incident reporting, having the employee meetings, having them understand the value of having the training, the safety checks, and that will allow you, from a company standpoint, to then draft your own analysis from employee training, and then track your incidents.
Yeah, I think one of the difficulties, of course, is that, again, that cannabis still being illegal. And I think, to state the obvious in this specific instance, and I think if we don't say it out loud in this context, we would be remiss here. But obviously, in particular with OSHA and air quality and worker safety around, all the grinding and cannabis dust. And that was an issue that I think it caught me by surprise when the big issue happened in Massachusetts a couple of years ago, where a worker actually died from cannabis dust inhalation. And it's really trying to anticipate. Now, we could go back and forth on whether it should have been known, but I think ultimately working by analogy, right, could have helped potentially mitigate that potential risk. Any time you have dust in the air, there's certain requirements, right? And there's other industries that you can draw from, sort of draw analogies so that you can sort of set up the SOPs properly with regard to worker safety.
Absolutely.
Perfect. I hope that answers your question, Renita. We'll move on. I believe we have one from Bill Perrier. Sorry if I butchered your last name. It seems that owners of social consumption places don't believe they have any liability if someone consumes at their place and then is in an auto accident. I believe that it's going to be similar to liability with a bar and individuals leaving a bar and getting an accident after that. I believe, you're going to have to assess whether there's going to be overconsumption, if they had a duty to know that that individual was going to drive, was overconsumed, and whether that location, enabled the overconsumption. Just from someone being there and leaving and getting an auto accident, that's not going to be a per se liability, but there is going to be an argument, and there should be procedures in place to ensure that there's no overconsumption and that there's proper processes if someone does seem like there's going to be some sort of overconsumption, or that they're going to that they're unable to drive and there's knowledge that their person's going to go into an automobile.
Yeah, from an insurance standpoint, that's a great question, Bill, and that's the one thing that as we go through and look at case law and try to understand, from a liability standpoint, they are liable if they're serving it in their establishment. But then it gets into the legal part of it is, was it the two rum and cokes and then the one THC drink? And that's where there's going to be a lot of that's going to be battled out in the courts as far as who was at fault for that, whether it was were they overserved. And a lot of times what we're finding is a lot of people are trying these drinks out in public for the first time, and they're not sure how they're going to handle it. They shouldn't be getting behind the wheel, that's for sure. But there's other aspects to that too. If they fall, if they just trip and fall because they weren't used to how that feeling was going to be, is that establishment liable for that? And that's where it'll be up to the courts to decide on who's liable. But there's going to be a need for coverage, and there's going to be a need for them to have the correct coverage in place if they're serving hemp-derived drinks, THC drinks in their establishment at a consumption lounge. There's going to be their current policy is not going to give them coverage for that. So that is an important conversation.
And Brian, you brought up a important thing that people are trying these things in public. So even early education before serving is going to be important as well.
Yes, absolutely, and having them understand that this is gonna affect people and their mindset, and having you're not just trying another alcohol drink. This is gonna alter your mind, and it's gonna alter the way that you think and the way that you're out in public. So there's a lot of layers to this. Um, and it's certainly the business owner and the bartender or the waitress, the waiter, they should understand that this is, it's serious, and understand so there's a lot to it, and the courts eventually there'll be some lawsuits that'll come up from this for sure.
Yeah, I think, not to overly emphasize this, but I think it going back to, this is sort of related to the OSHA question, and then the way Jared just thought through this. It's a lot of what's going to be happening is assessing the risk by analogy, right? And really having to reason through it with matters that have not just simply have, the science isn't established for causation, and it hasn't been litigated. So you have to really draw analogy and really look at, related or analogous issues that have been litigated and draw from that.
Perfect. That's looks like all of the questions. Before we kind of sign off, I just want to give. Oh, we have one more. You guys okay answering one more? We're a little bit over time. You guys okay? Perfect. From Al, are folks concerned with the rise of nuclear judgments and the ongoing limited capacity of higher excess liability / umbrella limits, especially for auto liability and cannabis, among other concerns? What are the current players offering follow form excess / umbrellas?
I can answer that very, very quickly, Al. Yes, we are concerned about the nuclear judgments, as this gets tested more in court, and there's more of these that are popping up. The knee-jerk reaction is, the judgments are higher than what we're used to if it wasn't cannabis. And the nice thing about more capacity in the market, more markets out there, is it allows the cannabis market in whole to have higher liability limits, and to be able to offer umbrella limits where a few years ago you couldn't get an umbrella. And when cannabis first came out, you couldn't get a liability limit over $500,000. So that is helping, and the fact that we have historical data to support that this is a good business to write and it's profitable is a good thing. But as you get into auto liability, and as you get into the follow form on the excess umbrella policies, those are all evolving, and it's getting better, but it's not where the traditional or standard market is right now. So that's a good question.
Well, thanks for that question, Al, and thanks for the answer, Brian. I hope that answers your question, Al. All right, and so before we sign off, I just want to give Sohiko, Jacob, and Brian a last chance. If you guys have anything else you want to add before we sign off, feel free. Sohiko, we'll go to you first.
Yeah, I guess, just thanks again for the time, and a very fruitful conversation. And I think, hopefully hopefully this isn't overly redundant again, but having a good solid team to help reason through this, work through the complexity, and just frankly the complete unknowable and unknown, ever changing landscape. You got to price it in on the front end so that you don't overpay on the back end.
I would just say, appreciate everyone's time. I thought it was a great conversation. We could obviously go down a rabbit hole in any of these topics. It's very complex, but at the end of the day, it's a human to human business as much as technology, as much as all this stuff is involved in our new society. And, really have that relationship with your lawyers, with your attorneys, with your risk managers. On the karma side, you can call or text any of us and talk to a human and really talk through everything. But I would just stress, have that real relationship and invest in it because it can really reduce the issues downline.
I agree.
Perfect. Yeah, and as we talked about, the regulations are ever changing. Hopefully we can see some federal reform here coming up, and we can all dive into what that means for the industry and how those are going to impact current operations. And we can dive into that more when that does occur. And first off, I just want to say thank you everyone for attending. Thank you, Suhiko, Jacob, and Brian for being a part of the panel and having this fireside chat. If you guys are interested, you can reach me or Suhiko at Cogent Law.